Hello and welcome you again, students. So, after discussing the brief introduction, history, and background of the International Criminal Court, so now here I'm going to deliver the lecture on the establishment of the International Criminal Court. So here I'm going to share with you slides. Students, here are the slides and the establishment of the and international tribunals. The first was the proposed in 1919 following the First World War to judge political leader accused of the international crimes. The Geneva Convention in 1937 was the first stipulating the establishment of the permanent international court to try the acts of the international terrorism. It was signed by the 13 states, but none ratified and never entered into force. Following the Second World War, the Allied powers established two ad hoc tribunals to prosecute Axis power leaders accused of the war crimes. The International Military Tribunal, which sat in number, prosecuted German leaders, and in Tokyo prosecuted Japanese leaders. In 1948, the United Nations General Assembly first recognized the need for the permanent international court to deal with the atrocities of the kind prosecuted after the Second World War. Finally, United Nations General Assembly convened a conference in the Rome in June 1998 with the aim of the finalizing the treaty to serve as the court statute. On 17 July 1998, the Rome Statute of the International Criminal Court was adopted by a vote of 120 to 7 with 21 countries abstaining. The seven countries that voted against the treaty were China, Iraq, Israel, Libya, Qatar, the United States, and Yemen. Following 60 ratification, the Rome Statute entered into force on 1st July 2002, and the International Criminal Court was formally established. The International Criminal Court (ICC) is a judicial intergovernmental organization that sits in the Hague, Netherlands, but the court may sit elsewhere as per the article of the Rome Statute. The court is a permanent institution which exercises jurisdiction over the persons for the most serious crimes of the international concern. The ICC brought relationship with the United Nations through an agreement approved by the Assembly of the States Parties as per the Article 2 of the Rome Statute. The ICC have international legal personality and may exercise its functions powers on the territory of any state party and by special agreement on the territory of the any other state as per the Article 4 of the statute. And how does the ICC differ from other courts? ICC is a permanent autonomous court, whereas the ad hoc tribunals for the former Yugoslavia and Rwanda, as well as other similar courts established within the framework of the United Nations to deal with the specific situation, only have a limited mandate and jurisdiction. Prior to International Criminal Court, two tribunals was created, and thereafter two ad hoc tribunals was also created, but those created for the specific work and for a specific with the limited mandate and jurisdiction. So thereafter, the states and United Nations realize uh, the world state must have any permanent forum where those heinous and atrocities and those crimes which shock our minds, our conscience, can be prosecuted. So in the Genocide Convention, so the need of the permanent court was mentioned in the Genocide Convention. So the ICC, which tries individuals, is also different from the International Court of the Justice, which is the principal judicial organ of the United Nations, for the settlement of the dispute between the states. So how it works, the organs and organization of the ICC. ICC has four principal organs: the Presidency, the Judicial Division, Appeals, Trial and Pretrial, the Office of the Prosecutor, and the Registry. The President is the most senior judge chosen by his or her peers in the Judicial Division. The Office of the Prosecutor shall act independently as a separate organ of the court. It is headed by the prosecutor, who will conduct investigation and prosecutions before the court. He shall have full authority over the administration of the office and shall be assessed by the deputy prosecutors as per the Article 42 of the Rome Statute. And thereafter, the another organ, that is the registry, is headed by the registrar and is charged with the managing all the administrative functions of the ICC, including the headquarters, detention unit, and public defense office. And the appeals division shall be composed of the president and four other judges, the trial division of not less than 6 judges, and the pre-trial division of not less than 6 judges. The judicial function of the court shall be carried out in each division of the chambers. The appeals chamber is composed by all the judges, the trial chamber by 3 judges of the trial division, and the pre-trial chamber by the 3 judges of the trial division. The official languages of the court are Arabic, Chinese, English, French, Russian, and the Spanish. How those organs, their appointments has been made. The court will have 18 judges, selection criteria, equitable gender, geographical representation, no 2 judges from the same state, and the word principal legal system must be represented. It means principal states legal system must be represented and elected by a 2/3 majority of the state parties present and voting for the 9 years term and not re-elected. Reputation for fairness and competency in relevant areas of law such as humanitarian law or human rights. A judge may be removed from the serious misconduct or serious breach of his or her duties. So the appointment of the judges has been mentioned in the statute, Rome Statute 2002, in Article 35 to Article 36. And what is the independence and privileges and immunities? The judge shall be independent in the performance of their functions. They may not engage in activity which interfere with their judicial functions or effect. Public confidence, judges will serve on full-time basis and cannot engage in any other occupation. Conflict of interest, a judge shall not take part in the decision of a question that may individually concern to him. The court enjoys privileges, immunities in states parties. The judges, prosecutors, and the registrar enjoy the same privileges and immunities afforded by the heads of the diplomatic missions, even after the expiry of their terms of the office for acts performed by them in their official capacity. Okay, student, the Rome Statute on 14th July 1998, a conference of the 160 states established the first treaty-based permanent international criminal court. The treaty adopted during that conference is known as the Rome Statute of the International Criminal Court. Among other things, it sets out the crimes falling within the jurisdiction of the ICC, the rules of the procedure, and the mechanism for the states to cooperate with the ICC. The countries which have accepted these rules are known as the states parties and are represented in the Assembly of the State Parties. The Assembly of the State Parties, which meets at least once a year, sets the general principle for the administrative of the court and reviews its activities. During those meetings, the states parties review the activities of the working groups established by the states and any other issues relevant to the ICC. So, countries who has ratified the Rome Statutes, over the 120 countries are state parties to the Rome Statutes, representing all regions: Africa, the Asia Pacific, the Eastern Europe, the Latin America, and the Caribbean, as well as Western European and the North America. And the seat of the court is in The Hague in the Netherlands. The Rome Statute provides that the court may sit elsewhere whenever the judges consider it whenever the judges consider it desirable. And the court has also set up the offices in the areas where it is conducting investigations. And how it runs, and who fund who provide the finances. The court is funded by the contributions from the state parties and the voluntarily contribution from the governments, international organizations, individuals, corporations, and other entities. So students, so it was the very brief introduction and the background of the establishment of the International Criminal Court. And normally, International Criminal Court working in The Hague, which is the headquarters of the International Criminal Court, which is situated in Netherlands, but it is not permanent sitting, but on the desire of the bench and the judges, it can be replaced at anywhere where it is where investigation has been conducted. The Rome Statute 2002 apply the article of the Rome Statute apply on the establishment and creation and working of the International Criminal Court.